Hi and welcome to our video today. My name is Sandra Tricoli and I have with me here Ross from Bankruptcy Advisory Centre. Very well, thank you. I wanted to speak to you today a little bit about, the last 2 years, obviously with COVID, there was a lot of rules and regulations with what people can and can't do. For example, if you're a landlord, you can't bug your tenant to pay you rent. Or, there was all these extra incentives and things like that. Now that all of that has somewhat calmed down and things are back to where they kind of used to be, what does that mean for people? Can you tell me a little bit more about that?
Yeah. So as COVID has plateaued and the effects have started to wear off, banks are now allowed to chase outstanding mortgages.
Yeah.
Landlords are now allowed to chase.
A lot of people froze their mortgages. Yeah. And
the laws came through and they basically said, unless you have a debt greater than $50,000, you can't pursue it. If you do have a debt greater than $50,000, you have to give someone 6 months notice before you can chase them. It took a lot of the stimulus out of chasing someone for a debt. Those things have all stopped.
Yeah.
So landlords are now chasing back rent. Banks are chasing back mortgages. The tax office, which is probably one of the most active creditors in the insolvency field, has been on a 2-year hiatus.
Yeah.
They're
like rubbing their hands now. They're like, all right, let's get back to business.
There's stats going around that show that over a nine-month period, the ATO only put 3 companies into liquidation.
Wow.
And they would normally be doing that to 10 plus companies a day.
So that means that the companies were kept afloat due to all the extra stimulus that was being given by the government. And
it was a bit of
everything, really.
The government giving on one hand made it very difficult for the government to take on the other. So the ATO basically said, look, let's just put a hold on these things. Now they're back active. They were
back with the vengeance.
they were in front of the Senate Estimates Committee a couple of weeks back, and they said, well, they advised the committee that they are actively back in the debt collection process. I read an article the other day that suggested the ATO had issued 50,000 notices to clients saying, you appear to be in arrears with your debt. If you don't pay, you can expect a director penalty notice.
Yeah.
Now, director penalty notice basically says you as a director have allowed the company to incur a debt that can't repay.
Wow.
And if you don't either pay the debt or put the company into liquidation or go to court to contest the debt, then the director becomes personally liable for the amount of money on the director penalty notice. Now, that's a huge ask for a director to take that responsibility on.
Yeah.
So directors who have received one of those notices should really take heed and take some urgent action. So
what would your advice be? Would it be to kind of have a chat with someone like Bankruptcy Advisory Centre, if they have been issued this notice? What would you say? Because a lot of people might, they know but they don't know the implications that can be incurred due to something like this. What would you say would be the best next step for people that are in that space?
If you've got the money, pay the debt.
Yeah.
If you don't have the money and you don't know what to do, you don't think you're going to be able to pay the debt, come and have a chat to us. It's free. We can advise you of the ramifications of the next part of the process.
Yeah, and the best steps to take.
Yeah, and you can then make informed decisions about where you want to go. Now, it doesn't mean that the company has to go into liquidation. There are voluntary administration, small business restructure, safe harbour options. There are myriad of options that are available. The earlier someone comes and talks to us, the more of those options.
It's almost like prevention over cure. If you come in early, then you're to a degree preventing the domino effect.
And once that director penalty notice is issued, you only have 21 days to comply.
Wow.
Okay. And the
does that mean to pay it back, or to pay some of it, or what would that mean? What does the comply mean?
The notice says pay the debt in full, which by rights would include a form of settlement with the ATO. But the ATO would take probably longer than 21 days to reach an agreement.
Yeah.
or put the company into an insolvent administration, or lodge a court application to defend the debt. Now, the only one that is likely to be achieved within 21 days is putting the company into some form of insolvency administration. But once you're in that, all your other options get taken away, and you don't have the capacity to. You're doing things under stress.
Yeah, it's not. You're not thinking clearly.
You get the notice today, or you've received that warning letter. You come and talk to us today. It might take the ATO another month to issue those notices. So you've got a month to actually look at your options, make an informed and a non-stressed decision, and get the best outcome.
Yeah, interesting.
But look, the ATO are back in the.
They're back in business.
Yeah, and that they are persistent. The debt does not go away.
Yeah.
They will negotiate on penalties and interest once the debt